Did you like that? If you want to use it at a wedding, it's going to cost you. In this week's video, we're going to be talking all about how to use music legally at weddings. Stick around. Hey out there, welcome back. My name is Rob. I am a wedding industry lawyer, and in this week's video, we're going to be talking all about using music at weddings and events. And don't be mistaken, this is not just for DJs or videographers that use music in finished videos. This is also for wedding venues and anybody that's in the event industry that is in any way touched by music. This video is for you, but we are not doing this alone. We have an extra special guest this week, entertainment lawyer Gordon Firemark. Gordon Firemark has practiced media and entertainment law since 1992. He is often referred to as the podcast lawyer and is himself a podcaster, producing and hosting the Entertainment Law Update podcast since 2009 and the More, Better, Faster podcast, which offers insights and advice to creative professionals and businesses who want to achieve more, better, and faster. Gordon is the author of the podcast, blog, and New Media Producer's Legal Survival Guide, and creator of several online courses for creatives. He's extremely knowledgeable in the world of copyright, publishing rights, and all things having to do with music and entertainment. And we are so happy to have him on the show. Gordon, welcome to the show.
Hi, Rob. Thanks so much for having me on.
Fantastic. So let's dive right into this. I think that with regard to wedding and event professionals, this topic has to start with the concept of music being something that is subject to copyright. Can you just give us a broad understanding of what copyright is as it pertains to music?
You bet. So copyright is a bundle of rights that belongs exclusively to the author of any original creative work that's fixed in some tangible form. So whether it's music or a poem or a sculpture, if you create it, you own it. And the rights that you own are the right to make copies, to make derivative works, things based on or that incorporate the work, to distribute those copies, perform it in public, and display it in public if it's that kind of a work. So every piece of music created in the last 95 years, we should really assume it is still protected under copyright law. And when you use recordings in particular, you've actually got two copyrights to contend with, because the songwriter sat down and wrote a song that makes a copyrighted work, a musical composition. And then the recording artists go into the studio and they make a recording called a master recording. That's a separate copyrighted work. And to just complicate things, they're usually not owned by the same people. So it gets tricky really fast.
It's never easy.
No.
So understanding that, so let's talk about this then. We'll go kind of maybe industry by industry. So let's say that you're a wedding venue,
Mm-hmm.
and you have either a band, a live band, or a DJ that comes in your venue for a wedding, and they play the cha-cha slide. Okay. What are the legalities, understanding that there's copyrights and there's two kind of components to the copyright? Is there any implication at all for that wedding venue when cha-cha slide is played?
Yes, there is. So the venue is engaging in at least one of those rights. That's the right to perform the work in public. It's happening in the venue. So there's a performance, and that performance right really belongs to the composer or the publisher that controls the copyright in that musical composition we were talking about. There isn't such a concern about the recordings, and that's just because of a peculiar wrinkle in the copyright law. But just understand that for a live public performance of a recorded piece of music, there is no royalty requirement. In any event, though, in the United States, we have organizations, they're all over the world actually, called performing rights organizations, and they collect those royalties for the live performance, what we call small performing rights. So if it's not part of a stage musical or something, it's a small performing right. And nightclubs, restaurants, bars, coffee houses, and wedding venues, and theaters as well, all have to pay these performing royalties. The organizations that do this here in the United States are ASCAP, which stands for the American Society of Composers, Authors, and Publishers, or BMI, Broadcast Music Incorporated. And there's a couple of others. One's called CSAC and the other one's called Global Music Rights. But those are the four here in the U.S. And the way they generally do it is by charging venues and, even dance studios and karate studios and things all have these licenses they have to pay for. It's handled on basically a blanket basis based on the size of the venue, maybe the annual revenues of the venue, or sometimes it's the number of speakers mounted in the ceiling. All those kinds of things are factors that are used in determining what that annual license fee is. So if you're running a venue where music is going to be used, you should expect that you're going to hear from these organizations, and they're going to ask you to pay for a blanket license. And then it sort of covers everything that happens in your venue that year.
So if I understand correctly, Gordon, if I'm operating a venue, I just started one, or maybe I've had one for a while, but I've never heard of CSAC, I've never heard of BMI. What's the process by which somebody can try to get compliant with them? Do they just reach out to somebody and say, hey, CSAC or whatever, like, I got your money for you, or what's going on? Like, is there like a 1-800 number? Like, how do we get compliant with the people?
Yeah, it's a little challenging. I mean, oftentimes a new venue will hear from these organizations from them. They'll sort of initiate the contact. They're on the lookout for these kinds of things. But if you are just if you built something from the ground up and it's never been in business before, yeah, you're probably going to want to reach out to these organizations. I would start with ASCAP and BMI and, get the process rolling. Just go to their websites, and they're terrific websites. They've got a lot of great information on them as well. So ASCAP.com, BMI.com. CSAC and GMR are smaller, and GMR is relatively new. Doesn't mean you shouldn't deal with them, because some of the big popular artists are on GMR. But start with the big ones where most of the catalog lives.
So if I kind of understand it correctly, then it's almost like paying a subscription to Spotify. If I have a subscription to Spotify, I can listen to whatever I want all the time, no problem. In this instance, the venue is paying these PROs some type of licensing fee, whether that's monthly or yearly, and that allows the venue to have open to the public performances, quote unquote, for the wedding and events they're having, and the live music there, without the fear that the owner of one of the copyrights is going to come sue them for copyright infringement.
Exactly. And in fact, just to clarify, because you brought up Spotify, folks who run venues should know that the normal Spotify license that you buy just to listen on your own devices doesn't cover you for using it in your whole venue. So you still need to get these permissions. Now, there are subscriptions to Spotify and Pandora and other of these music services where they've sort of taken care of it all for you. But if you're bringing in DJs and bands, you can't be sure that that's going to do it. So as a general rule, don't pipe your Spotify account through the PA system in the venue.
I can't tell you how many times I've been to a gym or a restaurant, whatever, and you hear music. It's like, that's great, and then you hear the advertisement for Spotify. Yeah. It's like, oh, that's bad news.
Right. Spotify does offer, I think all of them do offer commercial accounts, and they may even be ad free in that regard, let you drop your own ads in or something like that. So if that's what you want to do, check it out. I think it's a good way to do it, actually. But back to your initial point, it's a subscription. Yes, it's like a subscription. I would liken it more to paying a utility bill. You want to provide music in your venue for your customers to enjoy the same way you want to provide lights and heat and a water supply and those kinds of things. So it's a cost of doing business.
And I want to make this abundantly clear to the wedding venue operators out there that we're not talking about this applying only to if you're literally playing the radio or playing Spotify. I'm talking about this applies to you if a live band comes into your venue and plays the cha-cha slide.
Yes.
Or a DJ comes in. It's the same concept, that you're going to have to be correct with PROs.
Yeah, and the PROs look to the venue, not to the individual DJ or the band for these things.
Gotcha. So actually, that's a terrific segue, Gordon. Thank you. So what does the wedding DJ or the event DJ need to know about copyright and about PROs? How do they get right with copyright law and PROs?
Well, a DJ who's just spinning records probably doesn't have a lot to worry about in this regard. I think it would make sense if you're a DJ to ask and make sure the venue does have the necessary proper licenses in order, and that the relationships between the parties make it clear who's responsible for this. And it's easiest for the venue to handle it, and they can pass those costs on to their clients and customers and so on. And the DJ really doesn't have much to worry about. Sometimes the relationship between the venue and the DJ will specify, we're going to take a portion of a fee or something like that. I wouldn't normally recommend complicating things that way.
That makes sense.
So unless a DJ is playing music that isn't part of the sort of mainstream, if you're doing mashups, if you're doing new arrangements, if you're creating your own original adaptations of things, you may need rights beyond what the PRO license covers.
That makes sense, and we'll open that bag of worms here in a second.
Yeah.
But I want to really jump on this concept that is it best? Let me put it this way: the hypothetical is this. Then, what are the ramifications if the venue is not straight with the PROs? The DJ comes in, the DJ is playing, regular top 40 cha-cha slide.
Yeah.
And let's say the one of the two, when we talked about the copyright holders, the one that holds the publishing, they walk in and it's like, hey, I want my money for the cha-cha slide being played. Is it the wedding venue is the defendant? Is the DJ the defendant? Or are they both defendants?
Well, we lawyers we'll take the broad approach and name everybody in the lawsuit, and hopefully they'll fight among themselves and we can stand back and watch until someone comes out as being the party we should focus our attention on. So I would say that's the risk for a DJ who doesn't check in with the venue and make sure their license is in order, is that you get named in a lawsuit, and either your insurance or your house ends up paying your lawyer's bills.
That makes sense. Let's kind of jump a little bit to the individuals that are wedding videographers. And wedding videographers, typically they'll record all day. Perhaps the video footage has music in it, perhaps, and most often the video has accompanying music that they put in post-production. So what are some of the implications in that regard? Is it the same thing with PROs, or how do they go about that?
No, the PROs don't cover video or film or other kinds of uses, because what's going on isn't now there may be a public performance of that video at some point, but what's going on is the videographer is incorporating the music into a new original work, and that's what we call a derivative work, one of the guaranteed rights under copyright. And in order to do that, you have to make a copy of the song into your thing. So that's also the copying right, and then distribution gets involved as well. So you've got in any film or video production business, what we talk about are having to license those two separate copyrighted works. When you're using someone's musical composition, whether you're capturing it during just a live filming of what's going on, or whether you decide to put it in post-production, you're incorporating someone else's work into your project. You're required to have what's called a synchronization license for the musical composition, and for the recording. Remember, I said it's called a master recording. We call that a master use license. So you have to go to the owners of the composition, and I said owners because it's often more than one music publishing. They you have three songwriters. They write a song together. The band splits up. They go their separate ways. Now you've got three music publishing companies. If they've had children and died, then there might be. I've actually had somewhere I've had to deal with 15 different companies just in order to get one song. On the other side of it, on the record company, it's usually just one that owns the recording in question. And you have to negotiate deals directly with them. There's no blanket one-stop shopping or flat fee kind of a rate for those kinds of things.
So that sounds much more complicated than the live performance component of this concept. So
it sure can be. Yeah.
It is, and this is my ignorance of videography, but I'm assuming that there are services that already do that for you. In other words, maybe you pay a subscription online and you get, not necessarily clip art, but I see it on YouTube all the time. Like I'm hearing the same cuts of music, and I'm assuming that it's you pay some type of license for it.
Well, there are production music libraries where you can get, what I'll call stock music or production music for these kinds of purposes, based on either a subscription basis or what we call used to call it a needle drop fee. You just pay a license fee to use that song in this project, one-off thing, and you're done. Because you mentioned YouTube, YouTube actually has a library of songs that they're giving away for free, basically, to any YouTube user who wants to download them and use them in their things. And it is beyond just for the purposes of exhibiting things on YouTube. So that's kind of cool. It's not the greatest music in the world, and that's why you're hearing the same pieces of music over and over again, because they've got a fairly limited selection, but it's an option. But other than that, no, there is no clearinghouse. Well, there's a company called The Clearinghouse that does these kind of licenses, but there's no single place that you can go and just say, hey, get me these songs, and you're going to need to either do it yourself, do the legwork, or hire a clearing company to handle this for you.
That makes sense. And so, in other words, for the wedding videographer that is wanting to put the cha-cha slide on a DVD or I don't know, an MP4, whatever the kids are watching nowadays for their wedding videos, they're going to have to go straight to the cha-cha slide people, or go to Rihanna, or go to, whoever the case is, because that's much different than the PRO. That makes sense.
Well,
so the liability risk is higher because as you said, you're creating a new work.
Yeah. Let's talk a little bit about the law versus pragmatism.
Sure.
Because as a practical matter, look, if that videographer is out there filming and the couple's first dance, I can't imagine it being the cha-cha slide, but let's use that as the example. The couple's first dance is the cha-cha slide, and we have to show that in the wedding video, right? You can't not do that. So there's at least one piece of music that needs to be licensed. But the truth of it is, if it's just for the couple to have as their thing that they show their kids and grandkids over the years, chances are the record label and the publishing company are never going to know about it. But we live in this era, this day and age, where you transmit a digital video, you put it on a website, somebody downloads it, and then what they do with it is really beyond your control. And as the video company, the producer of that video, the editor of that video, you could be liable for having made that video in the first place when your customer or their niece posts it on YouTube and says, hey, look at this amazing video for my cousin's wedding.
That's right. So you're taking a risk, and that level of risk typically is going to depend on how popular or how that video actually gets used. So if it's only shown to the grandkids one time, 30 years from now, your likelihood of being sued is very minimal. However, if it gets on TikTok and gets 1 billion views in China, your risk of liability is probably pretty high, possibly. So,
and a couple other things on this, just real quick. So the good news is that the cost of these kinds of licenses doesn't have to be extraordinary. I mean, there may be a song that is so popular that the publisher knows and the record label know they can charge a premium for it. But if you want to use the electric side in a wedding video, and you reach out to the companies, first of all, they'll take a long time to get back to you. It's not a high priority to them because they know they're going to collect $100 and then be done, right? And they'll get paid, if it is on YouTube or TikTok or whatever, they're going to get paid those performance royalties we talked about every time there's a formula, but they'll get paid for those uses from YouTube and TikTok. But they do want to collect some kind of a license fee for the trouble of issuing you a piece of paper that says you can do it. And by the way, you should get that piece of paper every single time.
That makes sense.
And keep it.
let me, I'm going to actually go into a little bit of a crazy place.
Yeah.
I've been asked a few times in the past week, wedding venues, because of COVID, aren't able to put on true weddings. And so some venues are actually showing movies. So like, not drive-in movies, but, come in, you put your blanket 15 feet apart from the other family or whatever. And so the concept of, I'm charging $10 to come into this place and I'm playing a movie, not every day, and not like a movie theater, but like maybe once a month or once a week, showing something. You come, bring your food, whatever. What are the legal implications of that? I know I'm kind of flipping the script about music. Maybe this is, just movies.
It's actually really very much the same analysis, except that ASCAP and BMI and GMR and CSAC don't collect royalties they do collect royalties for the music in the movies, but they don't collect license fees that get paid to the owners of the movie, which is, after all, a copyrighted work. And in fact, this is we see these kinds of things happening a lot, even before COVID, with schools and camps and things like that. And they're supposed to have licenses to do that. The distributors of the film are the ones who have the ownership and control of the right to perform the work in public. And so if you're going to do this, you've got to get the right permission. It's one thing, the permission that you get when you buy a DVD or a Blu-ray or you sign up for Netflix or whatever, is limited to in-home personal use. And technically, I've even heard the argument that if you have 25 people over to your house and they pay something to, to chip in for the pizza, you could be liable. I don't see that being a big issue, but when you're in the business of hosting these events, it's a thing. And, just so you know, the typical deal between an exhibitor and a film distributor is that the distributor's getting half or more of the money that you generate at the box office. So you better be making your money from selling popcorn if you're doing this.
That makes absolute sense. And so if a wedding venue wants to do that to kind of, have a side hustle,
Mhm.
is there some website that you go to find the distributors, or is there some website that you can find out who you would need to, what company that you would need to talk to get that limited right to show it?
I'm not aware of any single site that's going to be the end all and be all of this. You're going to, again, it's direct licensing. You're going to have to go to the correct distributor, or sometimes the studio. If it's an older film, the studio may have the rights back from the distribution. But I would say start with a website like IMDb, the Internet Movie Database, and see if you can identify the company, and maybe do a little Wikipedia searching to find out how do you reach the company, and tell them that this is probably what I would characterize as what we call a special markets use. And when you call up the switchboard, say, hey, I need to license an exhibition for the special market. Who do I talk to? You'll chase your tail a bit, but you'll eventually get to the right person who can tell you, yeah, go ahead and do it.
That makes sense. And so I guess, and so that I have the parlance correct, typically it's going to be the distributor that can provide that direct license, as opposed to the studio or the I don't know, I'm not using the right word, but it seemed like you use the word distributor.
Production company or studio.
Production company. Okay. And then I guess after a certain amount of time, the production company reverts back and probably has the rights to do the direct licensing.
Right. I mean, again, the big studios are also distribution companies. So if the film was made by Paramount, it's probably distributed by Paramount and Universal and Sony and those kinds of things. But you may be looking at a film that was made by a small production company and then sold into distribution through, some other, there's lots of distribution companies as well. So yeah, the last in the chain before the exhibition is usually the distributor. Again, unless it's an old film, the deal between distributors and production companies generally is a 7 to 10 year, or maybe sometimes 15-year long thing. So if you're looking at, I want to show Beverly Hills Cop from the 80s, you probably just go directly to well, that's Paramount, but that's a bad example, but you go directly to the production company. And if you call the production company and they don't own the right, they'll tell you, and they'll probably tell you how to reach the person at the distribution company to do it with.
That makes sense. And you probably don't have to show Beverly Hills Cop. They're probably going to remake it next year anyway. So,
well, they just did Coming to America.
Coming to America, yeah. And I want to kind of hop back on the concept of a DJ doing mashups of songs and how that relates to that. That's just because the DJ might be at a venue that is pays the proper licensing fees. The mishmashes and reworks of songs, remixes might not necessarily be covered under that. Can you kind of talk about that a little bit?
Right. So if the DJ is just doing a live, segue from one song to the next, or scratching in something and those kinds of things, I wouldn't worry too much about it. The PRO licenses are going to cover that. But if a DJ is someone who spends their time when they're not doing the live event in the studio making their own mashup recordings and new arrangements and those kinds of things, those need permission from the copyright owners. That's making derivative works. And again, that's direct licensing, not covered by something like a PRO. So if you're a DJ and that's what you do, you want to investigate this further and talk to a lawyer who can sort of help you figure out what you need to do. Many times the owners of those recordings don't want you to reuse them that way. These are artists. Artists tend to think that their work, the way they created it, is the way it's supposed to be. Right. So songwriters are a little, a little more accustomed to this because people do cover recordings all the time, and cover recordings are covered under a special provision of copyright law that just sets a flat royalty rate and you're free to do it. But a mashup isn't just a cover. So that's what you have to be careful about.
That makes sense. Well, Gordon, I really appreciate your time. This has been super informative, and so glad that you could take time and talk to us today about this stuff.
Well, I'm really glad to help out. I'm happy to have been here.
Well, I hope that you found this video informative. If you did, please be sure to like and subscribe. If you have any suggestions for content that you want to see in the future, let me know. Leave a comment down below. New videos every week. They drop on Monday. And with that, folks, we'll see you next time.